Personnel Committee. All right, we'll start out with roll call. Alder Galvin.
Here.
Alder
Here.
Dorf. Alder Dorf.
I was thinking the chair. Here.
Alder LaFave.
Here.
Alder Corpus Dax.
Here.
Okay, everyone on the committee is here. I'll look for approval of the agenda.
So move. Second.
All right, all in favor?
Aye.
That passes unanimously.
Oh, wait, except.
Oh,
Except
Oh,
as amended.
Right,
Okay.
except as amended.
Except as amended.
So what we're going to be doing is moving item 4 in front of item 3, and then item 5 in front of item 6. So when we go into closed session for item 5 of item 6, we can do it all at the
Together.
same time, okay?
And then we're gonna, or, wait, I guess we'll talk about holding 1 and 2.
Right, we're gonna,
We'll talk.
yeah, right.
We just,
We'll
when we
make
get
that
to them,
motion
I'll
to
just
hold,
talk.
but we'll move 4 in front of 3 so that fire can make their feel and get out of here, and then save the police for last.
So who made that motion?
Is it Dorf and?
Yeah. Dorf and LaFave, right? We made the motion.
Yes, yeah.
Okay, all in favor of the changes to the agenda?
Aye.
Okay, that passes unanimously. Okay, I'm looking for an approval of the minutes.
So moved. Second.
Okay, I have a motion and a second, all in favor?
Aye.
All right, and on to regular business.
So we're at number
So
We'll
we're
be
at
at-
number one.
we'll be at number 1. Okay. Number 1 is consideration with possible action on request by Alder Weary to discuss customer service standards and work expectations of inspectors. Investigate the addition of evening and/or weekend inspection hours. Alder Weary is not able to be here at this time and has asked it to be held to our next meeting.
In December. Our first
December.
meeting in December.
First meeting in December.
Okay.
So,
Motion to hold.
Second.
all right.
Okay, maybe what we should do then is, because I know he works, I think till 4:30, it's hard to get here, maybe we should, his request should go down to the end, the last. Ask him, it would be easier for him than to make, instead of always putting this off.
Well,
No, he was in the room here.
Oh, he was?
Yes, he has a meeting, he's currently in a
yeah,
meeting.
that's right, that's right.
I spoke with him
Yeah, that's
personally.
right, that's
He
right.
said to hold it till the next meeting.
Okay,
So-
that's right, he said.
all
Okay.
those in favor of holding to,
Sorry.
until our
That's
first
right.
meeting in December?
Aye, yeah.
I have a point.
Yes.
Okay.
Alder Sawyer?
Yes, thank you, Chair. We were at Protection of Policy yesterday, and I don't know if Attorney Chavez could speak to that. I thought we were going to send this back. Is that possible
This is
to
the
personnel?
exact same.
Or is this the same item?
It is the same item.
It's the same item. So the recommendation.
I mean, the recommendation at P&P was to send it to personnel.
Why do we have 2 items?
So I guess I just want to
Or the
make sure.
same item
we
going to
clarify
2 different committees?
So
at
we
the
actually
same
had
time?
it going to 3 different committees.
Oh.
Yeah. we
This
did.
item originated at council. It was requested by the alder that it be sent to INS and personnel. The ordinance that we have requires the person to identify a primary one, or requires identification of a primary committee that will ultimately report out to council. The recommendation was that it be personnel that be the final one, since it pertains to hours and work standards and whatnot. So when it went to INS, they did a discussion there, and it was going to be referred to here immediately after that, but it went to protection policy because they were also considering potential revisions to the policies for the inspection department. And so it went there, we had a discussion on it last night, talked about the different roles of both the alders and the inspection, had a bit of a training on what the process looks like. And so the recommendation that came out of P&P was to receive and place on file based on, P&P was to receive and place on file based on the information that was received there. So the next thing that was going to happen was to come here to address the final remaining issues, which were specifically the customer service
Okay.
and the outreach.
Okay,
That makes
okay.
sense. All right.
So we
So,
have to vote.
So
we still need a vote on whether we're going to hold this or not.
Okay.
The motion was to hold until the first meeting in December.
Mhm.
All those in favor?
Aye.
Any opposed? That passes unanimously. Item number 2, consideration with possible action by Alder Weary to explore partnering, joining the state of Wisconsin for health insurance.
I'd like to move that to the first meeting in December as well.
I have a second?
Second.
I have a second. All those in favor?
Aye.
Aye, that passes unanimously. All right. Item number 4, update and discussion on the Green Bay firefighters local 141 labor negotiations. You wish to go into closed session?
Yes, we would.
Okay.
I'll make a motion to go into closed session
Okay.
and I can read the
I need a second.
Second.
All those in favor?
Wait, I
Oh,
can read the
that's
language
right.
first. The committee may convene in closed session pursuant to 19.851E Wisconsin statutes for the purposes of deliberating or negotiating public employee contracts for competitive or bargaining reasons. The committee may thereafter reconvene in open session pursuant to 19.852 Wisconsin statutes to report the results of the closed session and consider the balance of the agenda.
All those in favor?
Aye.
That passes unanimously. All right, folks, we're in closed session again. I'm sorry, I have to ask you to leave until we're done talking about this.
Move to go into open session.
Second?
Second by Kathy.
I have a second. All those in favor?
Aye.
All right. Do I have a motion?
I would like to move that we proceed, direct staff to proceed as directed in closed session. Second.
I have a second and a motion. All those in favor?
Aye.
Ayes have it. And we'll move on to the next item.
We're going to number 3.
Now we're going to do number 3.
Why do you have so many things on the same night?
I know.
Sorry.
I might as well get it over with at one time, yeah, one thing.
Okay, before everybody gets comfortable,
Just don't.
just don't.
Wait a minute.
We've closed session.
Item number 3 is an update and discussion on the Green Bay Professional Police Association labor negotiations.
Are we
Do
going
we-
into closed session on
We're
that?
going to need to go into closed session on that,
We need to go into
folks.
closed session. So
Smoke them if you got them.
I'll make a motion to go into closed session. Second.
Second?
And I'll read the language.
All right.
The committee may convene in closed session pursuant to 19.851E Wisconsin statutes for the purpose of deliberating or negotiating public employee contracts for competitive or bargaining reasons. The committee may thereafter reconvene in open session pursuant to 19.852 Wisconsin statutes to report the results for the closed session and consider the balance of the agenda. And we have to vote.
All those in favor?
Aye.
Any nays?
Closed
Nope.
session.
Okay, we're in closed session. Okay, all those in favor of the motion to go back into open session? say
Aye. Aye. I was noticing the door closed.
Yeah, the door closed.
They're coming.
All right, that passes
Comfortable?
unanimously.
Right.
I'll entertain a motion for item 3.
Motion for staff to proceed as directed. Second.
All those in favor?
Aye.
Aye, that passes unanimously.
So now.
Proceed as directed.
Proceed as directed.
Who made the motion? You made the motion?
Yes.
And I second it. We can pause.
All right, we're going to proceed, Alder Corpus Dax will be back in just a few
No,
minutes.
yes.
Yes. All right, we are now on to item 6, consideration with possible action on the grievance filed by Officer Jeffrey Brand regarding the personal file entry report issued on December 17th, 2018. This grievance is before the Personnel Committee meeting at this time upon the mutual agreement of the parties for extensions of time rather than at the meeting that was first available after filing. This is a quasi-judicial matter. It is the goal of the Personnel Committee to provide and conduct a hearing that is both fair in form, appearance, and substance. To ensure that this hearing satisfies these goals, each member of the Personnel Committee, please confirm the following by stating, "I confirm."
Better wait for all.
Yeah, we're going to wait for Alder Corpus Dax. Okay. So by stating I confirm, I do not have an interest or conflict of interest in this matter, and two, I have not received any communication from any person or party about this matter. Alder LaFave, on
Yes.
item number 1,
I've received no communication.
or no, conflict of
Say aye.
interest.
No conflict of interest.
Okay, and two, I have not received any communication from any person or party about this matter.
Nobody, no.
Alder Corpus Dax, item 1, I do not have an interest or conflict of interest in this matter.
I confirm.
And two, I have not received any communication from any person or party about this matter.
I confirm.
Alder Dorf, item 1, I do not have an interest or conflict of interest in this matter.
I confirm.
And two, I have not received any communication from any person or party about this matter.
I confirm.
Okay, I can also confirm I do not have an interest or conflict of interest in this matter, and I can also confirm I have not received any communication from any person or party about this matter. Okay, a decision will be made based upon the labor agreement between the City of Green Bay and the Green Bay Professional Police Association in effect as of the date of the event complained of. The Personnel Committee will either announce its decision tonight or take the matter under advisement and have a decision at the next committee meeting. The Personnel Committee will make findings of fact and conclusions of law based upon the record before it. At this time, the following materials have been submitted into the record. 1, a letter from Human Resources Director Joseph Falls to Personnel Committee dated June 21, 2019, along with 7 attachments. A, documentation of an oral warning for Officer Jeffrey Brand dated August 9, 2018. B, personal file entry for Officer Jeffrey Brand dated December 4th, 2018. The original grievance number 2019-001, identified as Green Bay Professional Police Association Contract Violation Information Form, dated January 21st, 2019, and attached documentation. D, grievance number 2019-001, from Chief Andrew Smith, dated February 4th, 2019. Item E, amended personal file entry for Officer Jeffrey Brand dated March 22, 2019. F, letter from Human Resources Director Joseph Falls to Officer Jeffrey Brand dated April 25th, 2019. Does that match up with everybody so far? Okay, number 2, Personnel Committee report submitted by Attorney Carly Windorf with 19 attachments. A is Exhibit 1, reference map of incident locations. B, Example 2, Personnel Committee timeline. C, Exhibit 3, GBPD Professional Standards Pursuit Review. D, Exhibit 4, original grievance paperwork submitted by Brand dated 1/21 of 19. E, Exhibit 5, chief response to Step 1 grievance. F, Exhibit 6, HR Director Falls Step 2 response dated 4/25 of 19. G, Exhibit 7, speed calculations by Dave Hansen. H, Exhibit 15, Lieutenant Engelbrecht preliminary determination for the August 2nd of 18 incident. I, Exhibit 16, Lieutenant Engelbrecht preliminary determination for September 20th, 18 incident. J, Exhibit 17, Group Report 18-208661. K, Exhibit 18, GERT Report 18-210609. L, Exhibit 19, original personal file entry with 4 violations. M, Exhibit 20, modified personal file entry with 2 violations. N, Exhibit 21, pursuit policies in effect at time of incidents. O, Exhibit 22, new GBPD vehicle pursuits policy 2019. P, Exhibit 23, Brand documentation of oral warning from 8/9 of 18. Q, Exhibit 24, employee discipline records dated May 6, 2019. Here's 2. April 19th, 2019, and April 24th, 2019. R, Exhibit 25, preservation email Brand to Warwick. S, Exhibit 26, email communications regarding Brand and another employee discipline. That seems to be it. Does that match up with everybody? question?
Do you have the personnel committee report?
What exhibit would that have been?
Oh, I think it would have been either one or two.
Personnel Committee timeline, Exhibit 2.
There's a timeline and then there's another longer narrative.
Oh, right above this personnel committee report.
Thank you.
Yeah, we have.
Okay.
Thank you.
And
Well, I'm looking on this
Alder
document.
Galvin,
Yeah.
in what you just read, it's number 2, and then the attachments are listed
Oh,
as
it's part of the
attachments to
attachments?
that
Okay.
report.
All right. Next is our understanding that the grievant has requested a fact-finding hearing pursuant to section 3.8.3 of the labor agreement. The committee may decide whether to hold a fact-finding hearing. What are the parties' requests for a hearing?
I request that we do not have a hearing. I think what the committee should be looking at is the two issues of whether or not it should be dismissed based on the agreement he had on March 22nd, 2019. And then if it's not for that reason, it should be dismissed because due to untimeliness, he did fail to file with HR director in a timely manner. And then from there, those are the two reasons why I think we shouldn't have a hearing. And then because it should be dismissed. But from there, even if you do believe it shouldn't be dismissed, I think that there really isn't any factual dispute on what happened. I think Officer Brand is just stating that what he did not violate the policies of the police department. So I think from there, even if you do believe it shouldn't be dismissed, we shouldn't have a fact-finding hearing because I think the facts already been discussed by both parties.
Thank you. And with respect to the timeliness of the step 2 grievance, that's kind of where there's a gray area. In the collective bargaining agreement, section 3.7, the grievance procedure steps can be waived by mutual agreement of the parties, and it's our position that the city constructively waived them. I mean, the process is that once the chief promulgates his step 1 letter, then the timeline starts to toll from that date, and I think it says 15 working days from that date. Then the problem is that Commander Work continued to discuss this with both union representatives and my client, and then you have this March 22nd, what Director Faulds terms as an agreement. My client disputes that characterization of that, and I think that's why we're requesting the evidentiary hearing. There's an audio recording of that meeting in which it was my client's understanding that Commander Work was saying, I understand that you don't necessarily agree with the disposition in this case, but you're signing this to essentially indicate that you've received it. And I think there's some pieces on that audio where my client indicates, so I'm free to continue to challenge this. Commander Work says yes. I mean, if we had been following the collective bargaining agreement, it should have been done and over with in February, so I'm not sure why Commander Work was continuing to meet with my client and go over the way this was investigated, which is sort of another tertiary issue. And then on top of that, the step 2 grievance, if we're using the March 22nd date, which my client did not agree with, that was sort of the final piece of what the department was doing with this. He presented that step 2 grievance to Director Faulds on the 10th working day following that. So we're arguing that it is timely because the city constructively waived that sort of step 1 process, if that makes sense.
Without understanding how the contract works, I'll bet it does into these three. And so that's,
You said what?
because of the way the contract reads,
Uh-huh.
I think maybe what she's explaining may not necessarily make sense as to why she feels that it should be waived. But, okay, and then as to the dismissal about previous, that there was an agreement reached between the city and the bargaining unit?
They essentially chose not to continue to represent my client in that process because essentially the claims that we have are that he was not disciplined, I guess, for cause or based on, essentially there should have been other officers who should have been disciplined. There then was discipline meted out, not in conjunction with my client's discipline, but after he made those claims. He made these claims, I think he kind of started talking with Commander Warwick sometime in January, February of that year. This March 22nd sort of final disposition happens, and then they meted out additional discipline against officers based on my client's claims in April. So long story short, that March 22nd resolution is what we're terming as, he signed that, and I think it's in the committee's exhibits. He signed that, not necessarily saying he agrees with that or that's the disposition, but that he's signing that, acknowledging the fact that he received that. But what we'd ask that the committee consider in a sort of limited evidentiary hearing is listening to the audio of that recording. I think there's another recording and then several of the videos that are at issue. And I would also just offer, if the committee were so inclined to grant that evidentiary hearing, if you wanted to, I guess, review that independently and issue a decision at a later time. We don't have to waste your precious time this evening if you wanted to review that independently, but those audio and video files, we had attempted to submit in advance, but I guess the system didn't allow for that to be uploaded or whatever, so that's just the basis for the evidentiary hearing request.
I guess I just respond to say that it's very common that a police officer will receive a discipline and then we'll have the meeting with the chief, and that'll be on certain dates. Then in between that date and the 15 working days to file with the HR director, it's very common that the union meets with the police department to try and work out a resolution to that discipline, and I believe in this matter it happened. But that does not constructively push the date any farther out. I would agree that if the committee does not want to dismiss this matter, and they did want to move forward with an evidentiary hearing or look at the documents on their own time, we would have no issue with that, but I would just ask that the city and the police department could just do one more review of the documents submitted and then allow the community to look at it afterwards. So if you do not move for dismissal, then I think it would be okay to look at the documents after the fact versus having a hearing.
Any questions? It's an awful lot.
It is.
Mm-hmm.
It is.
Because the
This is
city
it.
is asking for dismissal on at least 2 points.
Well, for the whole,
Right.
based on two things, yeah.
Yeah, 2 things. And you're bringing up arguments that in and amongst themselves would probably require a couple of hours at least, I think, to get everyone up to speed where we would understand exactly what the points are trying to make. And then make a decision whether to even have an evidentiary hearing or not. And I hate to make everybody come in and out of here numerous times, but to do what's right for everyone, I think we have to take this into consideration.
I think we have to take more time with it.
And that's the way I feel at this time. I would want, I mean, it seems to me on the flush from what I've read, discipline was handed out, this is done. What you're bringing up things that give me some pause. And I guess I would want a better explanation from both sides as to why they feel the way they feel and as to how this should proceed. That's me. And the rest of the committee can certainly,
I had this printed and, because I needed, there were so many questions that I had as I was reading through it, so I couldn't just do that on the computer. So, and I just have a lot of sticky notes in here, and I have a lot of questions. And obviously, a lot of time was put into this on both sides, and I feel that it would be worth my time to listen, but I would need more, I would appreciate being able to review stuff outside of this meeting.
If I can add, I think what would be relevant to the dismissal would be the ability to listen to the audio of the meeting that you brought up. I think that would be good for the committee to listen to that. And
in committee or on our own?
On your own. I don't know if we have it tonight or not. If we do, I think it's about 9-10 minutes, I think. So I'd be okay with the committee reviewing that audio of that meeting with Officer Brand, his union representative, and Commander Warwick.
So if I'm hearing the committee correctly, it sounds like you guys want to determine whether or not it should be dismissed before you move on to an evidentiary hearing?
Correct.
And if that is the case, what you can do is accept all that information tonight regarding just the issue of dismissal, and then take the matter under advisement so you can make a decision. Alternatively, you could go into, or actually I should say that you should give the parties an opportunity to brief that if you guys are looking for additional information, because I think it is a pretty complex issue, and so both parties can be given a time frame with which to submit their positions on both sides, so that you guys have something solid to look at as to what their positions are regarding that matter.
Just as it pertains to dismissal. or-
Correct.
Tonight.
Correct.
Okay.
So what I would be recommending at this point is you accept the information pertaining to the audio, and then provide a briefing schedule for the parties to provide their written motions. And I would say that that would probably need to happen before the next Personnel Committee meeting, so that you can have it on the agenda at that point. And then at that meeting, you would determine whether or not you're going to move forward with it, and the parties can have their evidentiary hearing that night if you decide to move forward with
Kathy, do you have any questions?
No.
Veronica?
No, I think.
It's a lot.
Yeah.
So,
Yeah,
and
it's
not
a lot.
understanding
Yeah.
what
Yeah, I don't-
the contract
yeah.
works.
Exactly, well, even with me understanding the contract, I don't understand the contract, so I mean, it's, and it's changed a lot since I was on the job, so, and it would behoove us in the meantime, between now and the next meeting, to review all the pertinent documentation to this again, because if we do move into evidentiary, we can't keep pushing this off, so we have to at least start a process so that they have some light at the end of the tunnel when this is gonna be done. All right, I would entertain a motion then.
Well, do we have to have it at the very next meeting?
I was gonna bring that up. I
It's
mean, I
kind
know
of
we have the holidays
close,
around
yes.
the corner for brief, so I mean, if we went out to January, I think I wouldn't oppose any type
Okay.
of schedule you guys come up with.
I guess,
Nope, and that's fine too. And just as a reference, in that Personnel Committee report that we wanted to make sure that you have, that does sort of give the large overview, and then everything else is sort of supporting documentation. I have no objection to that, and I think we were just primarily interested in having you guys watch the videos, because those are sort of what all of the discipline is towards that.
So, and then videos, that, like, how many videos total?
I guess to be clear for me, I mean, our perspective from the city is that listening to the audio of the meeting
Yeah.
is kind of what's pertinent to this.
Okay.
And I guess my thought, and it's obviously up to you and the attorney Chavez, is that if you feel like there's no dismissal, then my suggestion would be, then we move forward with looking at all the videos and everything submitted by both parties.
but that would be at the hearing. So it
If
can be
that's-
explained, so we're not just watching video going, what's going on here? I mean, that
So we
would be
would
my-
watch the videos if we determine that it's not going to be dismissed. If we determine there's going to be a hearing, we would watch the videos at the hearing.
My suggestion is,
Well, you could do it two ways.
yeah,
Right.
So the first way would be you make a determination at the next committee meeting, or whichever one you hold, about the dismissal. And then at that point, you set the hearing for an alternative date so that you guys can allow the parties to prepare for that, and also allow yourselves to prepare for that. Or you can hold it that night. So then you could have,
Oh.
instead of having to have all of the videos shown at one hearing that day, you can either prepare to allot enough time for it to happen, so you can have it kind of on its own potentially,
Right, right.
or you guys can review them independently within that time frame.
I guess if I'm gonna watch a video that someone's trying to make a point on, I'd rather have that person present so that
Me
we can
too.
stop it and they can explain what was going through or happening at that time.
So then setting like the next time, if we determine not to dismiss, then at that next meeting in January, then we would then set the hearing date and maybe make it on its own, not a regular meeting, have a time that,
If
If we decide
you
to
can
do
do
that.
either way. If you guys are just gonna watch the videos all together, it doesn't really matter whether or not you have set a hearing further down the road or that day. But if you wanna allow it, because the idea would be that if you needed additional time to move things on your own, then you could set it for a later date. But if you're going to watch them all at once, you can either announce the decision that night and then have the hearing that night, or if you want additional time allotted for the specific hearing, then you can set it on its own hearing date, essentially.
which would make more sense, and it wouldn't, I just think it would be fair for us to just.
If we
Yeah,
decide to have.
If we decide to have a
its own
hearing, I think that we should give
Yeah.
people a heads up and give them time to prepare and not just go, oh, let's just have
Yeah,
it right now.
away, yeah.
So, yeah, I think the next time it'll be deciding, are we gonna dismiss it or not dismiss it? Then I would like to see us set a date to give them time so that they don't have to come in ready, and then what if we dismiss it? Then-
Are
Okay.
you opposed to that, Attorney?
Nope, that sounds fantastic.
Yeah,
All right,
And
so,
then- oh,
we're gonna, go ahead.
I do have the audio for the dismissal decision. I do think Attorney Chavez has that. I don't know if she has that like today. Okay.
So you can send it to us and we can listen to it on our computers at home.
Well, I think the idea was that we would listen to it right now.
We would listen to it right
So that you
now.
guys have that ability to ask questions.
Oh,
about it.
okay.
For that body.
Okay, now, talking timeline, we're gonna listen,
Is there a reason not to? I mean, that's really up to the parties if you guys want to open a closed session.
I mean, I guess I would prefer that they just listen to it on their own. That's what my thought was. Because, I mean, I don't know, there's a lot of discussion in there.
well, if we listen to it on our own,
Here,
and then
you're talking here in closed session. He's talking here
No,
in closed
no.
session.
No, I'm
So
talking
leave
just
this
on your
meeting,
own.
You go
and then
home,
we
you
go
go home
home
and
and we
listen
listen to it on your own, you review the paperwork, then when we have the next meeting to decide if we're gonna dismiss or not dismiss, if we have any questions, we could ask those at that time.
That's what I would prefer.
Reference the audio that we heard or any of the paperwork that we read.
Okay.
And
But, I
Attorney
mean, that's-
Chavez
I don't know
gonna
if
send
everybody-
it.
I'm sorry.
Just gonna send it to us.
My thoughts were, we review the paperwork on our own, listen to the audio on our own. Then at the next meeting that we have to determine dismissal or not dismissal, if we have any questions on that audio, we could ask them at that time and have them explain to us. Um,
That sounds fine.
Okay, just so I'm getting the timeline down here, when will we have the meeting, our very next meeting, would that be to
No.
determine dismissal, or are we talking
We
January?
talked January. We're talking January.
That's up to the committee and the attorney, however you guys want to do it. If you guys are ready to determine dismissal at the next meeting, I think we're okay with that. If you want to wait until
I don't-
January, I'm okay.
Well, here's my other concern, and not to say this thing is gonna turn into some Supreme Court hearing here, but we're all up for reelection, and we could all be gone in April, so, I mean,
It has to be
I
before
just
that.
don't want this thing to get so elongated out that,
No, I'm
I
not
think
seeing it
the
getting
bigger
elongated
issue
out.
is allowing the parties adequate time to
And that's-
to
well,
present
that's
their
fine.
motions, their written motions to you guys, or, I'm sorry, their written submissions in support of their positions. And so I think it's really an issue of whether or not they have adequate time within those 2 weeks to provide something to you and still give you enough time to actually review it.
We were
So with that,
talking
I
January.
guess the question is, what do the parties prefer? And then what does the committee prefer?
City, what would you prefer?
I think it's, if we're looking at to have briefs on the dismissal, and then after that, prepare for a hearing, I think we could have the dismissal meeting in January, and then I think we'd have the evidentiary hearing either late January or early
Mhm.
February.
Mhm.
I think that sounds fine, and just to clarify, between now and then the anticipated January date, that would be the sort of briefing. Okay, yeah.
We would get more stuff to look at. Okay. Because this is not enough. I need some more.
Okay.
So the next question I have is, would the committee like to establish those dates now, or would you rather we work with the parties as the law department to determine what dates work with them?
What? What?
What's? But it wouldn't be like on a Tuesday?
No,
No.
I don't mean that, I mean for the briefings to be submitted.
Oh,
Oh,
for
so
the
we're asking like,
briefings to
we
be
say we
submitted.
want it
I would prefer
by this
you-
time.
You would just take
The
it.
city and Officer Brand work that out between themselves.
You can do that.
'Cause
Thank you.
it's-
Then I will provide them with the deadline that it needs to be submitted, and they can determine their deadline.
Okay.
All right. Does everyone
So
totally
we're,
understand?
so we're gonna, the first
So she's gonna send
meeting.
us the video to watch, or audio. whatever.
The audio, yeah.
Okay, we'll listen to the audio. And then our first meeting in January, which will be the second Tuesday.
Yep, the 14th.
It's the 14th, because I didn't put my calendar, all right.
Okay.
January 14th, we will decide on
Dismissal.
Dismissal or no dismissal.
And then, depending on what happens then we'll take the next step.
Okay.
Okay.
Sound good to everybody?
Do you need a motion or anything?
We're gonna need a motion on this.
Yes, so the motion would be to hold until
January 14th.
January 14th
Okay.
for the parties to brief the issue of dismissal.
Okay, so I
with
need,
with the dates of submission to be determined by the parties.
Okay, so I move that we hold this until January 14th to brief the issue of dismissal with the dates to be determined by the city and the parties on what dates the information, the briefs have to be in to us by.
Do I have a second?
Second.
I have a second. All those in favor?
Aye.
Aye. Any opposed? That passes unanimously. All right, this part is settled till then.
Okay.
All right, on to item 5. Okay, consideration with possible action on the grievance filed by Officer Matthew Lynch regarding the attendance of canine training issued July 19, 2019. So I have this. Okay, when last we left this, we were in closed session and we had been asking for some information from the city on defining verbiage within the contract and as it pertains to this issue. So I would entertain a motion that we enter back into closed session to further discuss this and then render judgment.
I move that we go into closed session.
Do I have a second?
Second.
All right.
I'll read the language.
Okay.
The committee may convene in closed session pursuant to 19.851A Wisconsin statutes for the purpose of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. The committee may thereafter reconvene in open session pursuant to 19.852 Wisconsin statutes to report any actions taken during closed session and to consider all other matters on the agenda.
All those in favor?
Aye.
Any opposed? Okay, we're in closed session. Hate to do this to you guys again. Paul, it's the most moving you. All right, entertain a motion to go back in open session.
Back into open session.
Second.
All right, all in favor?
Aye.
Aye. All right. To both parties, I mean, we have listened to you and gone back and forth. We kind of have some legal expertise rendered to us to try and understand the various nuances in the contract and the management rights. And so I've got a long list of finding of facts, but we're going to cut right to the chase, and I'll entertain a motion.
I'll make a motion that we deny the appeal.
Okay. Second, all in favor?
Aye.
Aye. And that passes unanimously, and I'll read to you our findings of fact. This matter was heard by the Personnel Committee on October 8, 2019, upon the mutual agreement of the parties for extensions of time rather than at the meeting that was first available for filing. Number 2, the parties were provided an opportunity to submit written documentation in support of their positions, which documents were admitted into the record and considered by the Personnel Committee in making their determinations. Number 3, neither party requested a fact-finding hearing, and the Personnel Committee similarly determined that a hearing was not required in this matter. However, both parties made oral arguments in support of the written submissions at the meeting of October 8, 2019. Number 4, the Personnel Committee took this matter under advisement and continued the matter until November 12, 2019. Number 5, the relevant provisions of the labor agreement in deciding this grievance are sections 1.2 management rights, section 3.5 removal from specialty team or assignment, and section 7.3.3 pertaining to K-9 unit training. Number 6, pursuant to section 3.5, the parties acknowledge that Officer Lynch has not been removed from the K-9 unit. Number 7, section .3.3 provides that the K-9 officer shall be responsible for 17 hours of maintenance training per month on a yearly average. Number 8, section .3.3 further provides that when feasible, all K-9 officers will train together as a unit. Number 9, section 1.2. Management rights provide in part that the union recognizes the prerogative of the city, subject to its duties, to collectively bargain, to operate and manage its affairs in all respects in accordance with its responsibilities, and the powers and authority which the city has not abridged, delegated, or modified by this agreement, are retained by the city, including to delete the positions from the table of organization due to lack of work, lack of funds, or any other legitimate reasons, and to determine the methods, means, and personnel by which the city operations are to be conducted. The city agrees that it may not exercise the above rights, prerogatives, powers, or authority in any manner which alters, changes, or modifies the terms of this agreement as administered. Number 10, the labor agreement is silent as to what happens when a dog position in the canine unit is eliminated. Officer Lynch's dog partner has been retired from the city's canine unit, and as such, Officer Lynch does not currently have a dog assigned to him. The city has decided not to add a new dog to the canine unit and instead has effectively elected to eliminate this dog position from its canine program. Based on the elimination of a dog from the canine program, the canine unit has more officers than dogs. Number 14, Officer Lynch has not been removed for cause from the canine unit. Number 15, the GBPPA argues that because any officer may only be removed from a specialty team, position, or assignment for cause, and because the labor agreement provides that when feasible, all canine officers will train together as a unit, Officer Lynch is entitled to attend canine unit training regardless of whether he currently has a canine partner or whether a dog position has been eliminated. Number 16, the city argues that regardless of whether the officer remains a member of the canine unit as they have not been removed for cause, the city retains the right to limit training to canine officers who have a canine partner pursuant to its management rights. Conclusions of law. This grievance is properly before the Personnel Committee pursuant to Article 3 of the Labor Agreement. Number 2, a hearing on this matter was timely conducted in accordance with Article 3 of the Labor Agreement. Number 3, a contract is ambiguous when its terms are reasonably susceptible to more than one interpretation. I will not cite the case law, but it's included on the conclusions here. Number 4, an ambiguity may also be created when a contract is silent regarding terms. Number 5, if a contract is ambiguous, it must be interpreted to avoid absurd results. Number 6, the parties have presented two equally rational interpretations of the contract.
Sorry, I didn't quite.
Sorry. Okay. Number 7, upon review of the contract and submissions and arguments of the parties, the committee has determined that the labor agreement is ambiguous with regard to this matter. And number 8, because the labor agreement is ambiguous as to what happens to the canine unit when a dog is eliminated from the program, the city retains the right to limit training to canine officers who have a canine partner pursuant to its management rights. And we gave you the vote at the beginning of this. This will be signed, and you will receive a copy of this, as I'm sure you're certainly going to entertain the thought of taking this further. Okay? So all that information that I just read off will be there for your attorney to review and use it as he sees fit. I thank both parties for their time and effort in this, and hopefully, something can be worked out in the future as it pertains to this unit. Thank you.
Thank you. All right, thank you for your time and continued consideration on this. Have a good night.
Good night.
Still have some more stuff.
Why is my finger not? Okay, we're down to E, informational, review of the WRS eligibility of physical fitness incentive grievance.
So we have a resolution for this grievance, so it no longer will be in front of the committee.
All right,
Okay. Oh, good. Thank you. Good. Oh.
well done, Joe.
So you don't have to-
Well done. Okay, so we need a motion on this, or we can
Just
just,
receive and place on file.
Motion to receive and place on file.
Second.
all in favor?
Aye.
Aye.
Okay.
All right. Number 2, Parks Department will begin recruiting the WLS superintendent position to begin January 1, as approved in the 2020 budget.
And as this position was approved in the budget, we're just letting you know that we're going to start recruiting for it.
Okay.
Okay. Routine, report of routine personal actions for regular employees. Any,
Do you have any
No.
comments?
okay, and the next meeting date is November 26th.
If needed.
If needed.
If needed.
So we're gonna keep it on, and then we'll let you know if we have any
Right.
items.
Yes.
I
That's
will
what we
notify you
decided.
right now, I will be out
No
of
more
session.
closed sessions, please.
Well, we got some of those coming up next year.
Yeah, the monthly sessions for this year.
Yeah, yes, for this year.
That one,
Move to adjourn?
probably gonna be a little, yes,
Okay.
Second.
go. All in favor?
Aye.
Who seconded that one?
I moved it.
I seconded.
Yeah, she seconded it.
I would think so.
Um,